Hi, everyone. Great to see people starting to pile in. We're seeing the attendee list go up rapidly here. I see 40, 45, 50, 60 people are piling in, which is great to see. So everyone, as people are still coming in, thank you for attending the Security Token Landscape webinar. So this is a webinar for lawyers and other legal professionals. Of course, not everybody joining the webinar as an attendee will be a lawyer, but we are going to go a bit deep into the weeds on this. So this isn't going to be your typical what is a security token, what is a blockchain type webinar. We want to get into some really meaty issues because we do have some of the top legal minds in the space here. For anyone who doesn't know, I'm Graham Moore. I'm the head of tokenization at Polymath. Polymath, we have a platform that makes it easy to create and manage security tokens, so actual financial securities on a blockchain. And our most recent development is we are building our own blockchain for security tokens. And so that's called Polymesh. And we're hoping to go live with a mainnet on that very soon. Before we get into all of the fun stuff, we have to do what a lot of lawyers will be very familiar with. We will be reading a disclaimer. So everyone sit tight for 2 minutes while I read this out so that our legal counsel will be happy with this webinar. So this event is offered for general, informational, and educational purposes only and is not intended to constitute legal, tax, accounting, or investment advice. Any and all information or opinions shared during this event by Polymath or any participants is solely for informational purposes only. In addition, anything discussed or shared during this event shall not be considered to be investment advice, recommendations, or solicitations to purchase or sell any securities mentioned during this event. Polymath is not a broker-dealer, funding portal, trading platform, investment banker, underwriter, or otherwise engaged in the business of trading in securities or providing advisory services regarding the issuance, buying, or selling of securities. So thank you, everyone, for sitting through that. And I think we can get started. And so first things first, I'd like the panelists to introduce themselves. So Nina, why don't we start with you first?
And thanks for inviting me to this panel. I always love discussing with the colleagues. I'm looking forward to our talk, John and Josh. Yeah, my name is Nina Siedler. I'm a German lawyer, partner at DWF, which is a quite tech-oriented global law firm. I personally focus on financial regulatory and governance topics, but we have a team looking at blockchain and DLT stuff from all angles. Within DWF, I had the Global Blockchain Competence Group and had also been very much involved in the community stuff out there. One of the founders of the German Blockchain Association. We formed a European legal think tank in Luxembourg, and 2 years ago, I assisted the European Commission in forming the International Association of Trusted Blockchain Applications, where I'm still currently one of the directors on the board. That's it for me.
Thanks, Nina. John, could you go ahead?
Hi, John Salmon. I'm a partner in London, based in London, in a global firm, Hogan Lovells, and I lead our global blockchain group there. So I've been doing kind of fintech nonsense for more than 20 years, which is pretty horrifying when I think about it. And so I've been doing kind of crypto and digital assets for the last sort of 6 years or so. I'm a techie at heart, but kind of got the fintech bug, and ranked as kind of one of the leading global fintech lawyers. So we have a kind of cross-sector, cross-practice global group, and it's good fun looking at what we're doing across all sectors and disciplines.
Great, thanks, John. And Josh, finally. Hi,
I'm Josh Clayman. I'm senior counsel at Linklaters, where I head our U.S. FinTech and Digital Economy group. And I also am U.S. head of FinTech and head of blockchain and digital assets and a global tech sector co-head. I am part of a global practice as well. And I've been in the space a while. It's a great passion of mine. By background, I'm a corporate and finance deal lawyer, but over the years, being in the digital asset space, I've become a regulatory lawyer as well.
Great.
Thanks for having me
here. Yeah, happy to have everyone here. And so for any of the attendees that are watching, feel free to ask questions at any time. You can do so through either the Q&A button you'll see there on Zoom. And you can also post in the chat. So we'll have someone from the Polymath team who's answering some of your questions. And then if we really like one of the questions, we'll actually pose it to the panelists near the end of the talk. So feel free anytime, ask some questions. And then there will also be polls that will pop up in the Zoom. Feel free to answer them if you'd like. You don't need to, but just interesting to see who's on the webinar and what they're interested in. And so let's get right into it. As soon as we sort of got on the call before the panelists started, or before the attendees started joining, John and Nina were going back and forth. And John, you said something really interesting that I wanted to dive into a bit deeper. So the definition of tokens is really bad. Can you explain what you mean by that and go into a bit of detail?
Yeah, Nina and I were having a rare old time, as we would say in Scotland, talking about geeky law stuff. But I think, so what we were referring to, Graham, was that there is a very new, interesting proposal from the EU, came out in September last year, called Market and Crypto Assets Regulation, or MiCA. And you know, whether we like it or not, and Nina and I have our own observations on it, as we've already said, MiCA, like GDPR, will probably become the global de facto standard to some extent, because it will cover the whole of the EU. So it's going to be very important to the sector. And one of the things that Nina and I were agreeing that we don't like, among many things, is the definition of crypto assets itself in MiCA is pretty poor, to say the least. And I think it is concerning that, you know, if you start with the wrong definition, then everything else is then suboptimal. But I think there's a, you know, as I was saying earlier on, I did a session on MiCA recently where I said I thought it was kind of, you know, about 70% right, and some of the other people said that they thought it was less than 50% right. And I think there's possibly a long way to go and a lot of discussions to go, but I think it will be very important as we become more regulated in the space. Then it will be a very important development. Right,
Nina, any thoughts on that?
Yeah, sure. I think you frame it right, John. The expectation, at least from the European Commission and Parliament, is surely that this will become more or less a global standard. And yeah, that's now interesting, Josh, to hear it from your end, because that's still quite away from, you know, the token classifications that you have in the US. And I think that's the most interesting point, maybe also for you, Graham. You know, what is a security token in the different regions of the world, right? And MiCA doesn't relate to security tokens because those are regulated in the MiFID market in financial assets already. And MiCA is only filling the slots, and that's maybe one of the problems that MiCA has. It doesn't, you know, regulate this area of tokens in a kind of natural way, but only in a leftover way, right? So it only regulates those areas which are not regulated yet, and it squeezes in artificially, you know, this crypto asset topic into the existing historical, so to speak, other financial regulations. And that's, I think, John, what leads to us feeling that this definition of crypto assets is somewhat strange.
Yeah, and yeah, it doesn't, for instance, talk about DeFi at all. You know, DeFi is not mentioned. But I think one of the other things that really leaves me cold on it is meant to, what they talk about a lot is create a level playing field between existing players and new digital players. Let's call them digital players, right? Even though that's probably a misnomer. And but they don't do that because they can allow a free pass, or the proposals allow a free pass to existing regulated institutions, which I think doesn't create a level playing field. It does exactly the opposite. So I think it's, you know, there's a lot wrong with it, and I think it's interesting.
Josh, you seem like you're going to chime in, please.
Yeah, what's interesting from my perspective, just in general, obviously I'm interested in MiCA, but you know, this whole concept, and we come up against this in practice all the time, I'm sure all of us, is that in certain regions, as John and Nina just noted, some things can be unregulated currently in the digital asset space. Whereas within the US, there really isn't a concept per se that something could be outside of the regulatory perimeter. Like, it's a case-by-case assessment with every digital asset. You look at the facts and circumstances, you ask yourself the Howey test factors. Is it a security, right? To find out if it's an investment contract, et cetera. And if it's not a security, then it's likely a commodity, right? Or, it may be treated as money in certain circumstances by FinCEN or state money transmitter regimes. And the IRS may treat it as property. So that's just naming a few, but there really isn't a concept that something would just be completely, okay, here's our regulatory perimeter, and then this is outside. And yet I know from working with my colleagues, throughout the world, and I'm sure John and Nina can speak to as well, outside of the US, there is a concept where you can say this is outside the regulatory perimeter, or we think it is, And so that, I think, is a key difference, is that in the US, there are no real classifications, hard classifications. I mean, there are, security tokens, et cetera, but you determine that by looking at the specific token and also the specific actions surrounding that. So it's a very facts and circumstances specific analysis every time.
And that actually, Josh, if I may jump in, was one very interesting learning I had from you on another occasion, that the US is so much looking at the transaction happening, right? We always start with analyzing, what type of token is that? And that determines then actually, how it's regulated. But you seem to have a different angle towards those things. And I think that's maybe also worth mentioning.
Yeah, I mean, I don't want to dominate this with the US. Certainly our conversation is global in nature. But yeah, I mean, the idea that under certain law, like for example, FINMA or other places throughout the world, you could have, like, the regulator has classifications, and you look at what the token does, right? And you say, what does this token do? And that helps you classify it. Really, in many cases in the US, it's how was this offered and sold? In addition to how is it being transacted in? Is it being treated as money, for example? Is it being, is it a security? I think everyone probably has heard the Howey test to death, but I will say it just once because it seems to be a requirement for everything related to security tokens, which is there an investment of money in a common enterprise with a reasonable expectation of profit based solely or primarily on the managerial or entrepreneurial efforts of others? So that isn't looking at what the token does at all. It literally is, what was in the people's minds when this transaction took place.
There still is an assessment, I guess, of facts and circumstances, though. I think it's probably just from a different angle, Josh. It is, I guess, you're right, there is a regulatory perimeter and there is stuff that sits outside it, but I guess it is more the function and attributes of the token, right, rather than as you say, but there still is a facts and circumstances, and certainly we spend an awful lot of time looking at that very thing, the facts and circumstances of the, of each case, because it can be very difficult to draw, that line.
Absolutely, and I am not in any way, I mean, you guys certainly are the masters of your various jurisdictions, so I'm not in any way saying that there isn't intense analysis with it. It's
just but I get, I take your point, but it's still there's still a lot of messing around to be done.
And then that also plays a role. I'm just having one eye on the chat here. This distinction between a pre-functional and post-functional token, right? To see if it's a security according to the Howey test, that doesn't at all apply to a MiFID security, right? So that doesn't play a role from our perspective. A token is what it is. And if the lawn is not laid, as I like to refer to this example with the golf course, and you sell the membership in the golf club, it will remain, from our perspective, a membership agreement and will not become a security just because the loan did not grow yet. And that's also an interesting differentiator to keep in mind. And I think, for us in Europe, MiCA, like it or not, will be a huge step forward, because we will get a harmonized regime across all European EU member states. And that will create a market which currently does not exist, right? Currently, if people want to issue something or build a service around any type of digital asset, they need to check with 27 jurisdictions if that works. And nobody's really doing that, right? So you're forced to limit yourself to your core markets. And, I think that that's a great opportunity. And it's also differently built from what you just described, Josh, for the US, that, all the different regulators claim that digital assets to be theirs, right? Money from one perspective, commodity from another, security from the next. So I don't anticipate us coming into such a difficult situation in Europe, but rather the other way around. Hopefully, we will get a clearer view on the legal side of token things here.
Right. John, on that note, where do you think the UK goes now? So MiCA's come out in the EU. You have the FCA, by some people's opinions, being a relatively forward-looking jurisdiction in terms of crypto and security tokens more broadly. We have Archax now being able to trade digital securities in the UK.
Mm-hmm.
Where does regulation go now? Are they just going to make sure, okay, everything that existed in the old world, all the regulations, we just port that over to tokens? Is there some leeway there? Are there going to be some new things that have to be developed? What are your thoughts there?
So one of the deficiencies of MiCA, as Nina and I were discussing earlier, is also that, and I think this is one of the deficiencies of the US as well, is that you apply the old clunky existing securities regulations to tokens, and often that's quite difficult, and it results in unintended consequences. And it's the same in certainly EU with e-money as well. E-money legislation, as it applies to tokens, can actually be quite difficult to apply and leads to unintended consequences as well. The UK have, not through the SCA, but through HM Treasury, which is so that the government have put out a consultation, which is currently we're helping various clients and other organizations respond to, and that is potentially set up to be a radical UK response. Nina was asking me, would the UK basically follow MiCA? Now, that's a big unknown question that I don't know the answer to, and I don't think the UK government have made up their minds on that. But I think politically, I think it's probably doubtful that they will follow MiCA, because I think, post-Brexit, the UK government to be doing their own thing. And I think the UK government do understand that, and I've been told that there are deficiencies around MiCA. So I think, they're keen to see whether they can do things maybe quicker and better. Because even if MiCA is agreed, as Nina were talking about at the beginning of next year, probably it'd be 3 years to implementation from now, Nina, I guess, or probably.
Yeah, the hope is that it will come into effect next year, but it will come with an 18 months grandfathering period, right?
Yeah.
But the interesting point, I think, if the UK does not adopt MiCA, then you're basically kicked out of the ring-fenced area. MiCA provides currently for only ventures established within the European Union to being able to make use of MiCA. So that's a choice to be made,
Yeah, exactly. And I think that's where I don't know where we'll end up, Graham, but I think that's where we will end up from a UK perspective. because I think even if the UK were to adopt MiCA, then they probably still would have to. You'd probably still, as a UK entity, have to form an EU entity because that's what MiCA says. So you know, I think it will. So I think the UK will perhaps, you know, I'm hopeful that the UK will decide to do something radical, and by radical I mean actually look at you know, digital assets and say what is really required to make this work and make this work well, and therefore become, you know, an attractive center for digital asset operations. But you know, we don't know.
Yeah.
But there's this. So I would say, so HM Treasury consultation, which I would, you know, please everybody that's got UK interest, please respond to that, because it is an important consultation, and I am hopeful that the UK will do something good.
Yeah, and similarly, yeah, don't we all? And so similarly on that, Nina, so Germany's draft Electronic Securities Act, to me, that was a very, very positive thing in the world, right? We saw BaFin come out and say, okay, you know, you can actually have a bearer bond and it can be on a blockchain. And we are not going to say you're a bad person and sue you or anything like that. And of course, you're nodding your head because we don't know for sure. But I was hoping you could talk about that act and what that means, not just for Germany, but for other jurisdictions and other regulators moving forward, how they can look at the space.
Yeah, there had been a long, really, you know, decade-long debate within Europe whether they could agree on all waiving their paper requirements. Traditionally, you know, there had been a couple of countries which required a paper for a bond and others which didn't. And actually, we must admit that a lot of countries waived their paper requirement in the meantime. So this is a step that is overdue, that we finally, you know, give up on this paper requirements for bonds in Germany. We are very happy that this is coming now, and we'll see if they still manage to bring this new law through the parliament prior to our new election. But expectation is actually that it will come into effect this year. Unfortunately, the blockchain thing in this context does not really work out that well, because blockchain is permitted as register for such electronic security, but only if there is a registrar which is regulated again, right? So it's not like, you know, you could use Ethereum also for issuing your securities token. But it's, you know, you need a centralized registrar with a BaFin license. And that one chooses the technology they would like to base this registry upon. And due to the uncertainties with regard to the public permissionless systems, there's a huge question mark if that law will actually lead to anybody using those systems for electronic securities. So it's like, you know, it's a half step into the right direction, and we would have wished, you know, a larger one than the one that is currently proposed. But nevertheless, getting rid of the paper is good in any way.
Yep, agreed. Josh, over to you. So there might be some people watching this webinar. They're considering launching an offering. They're considering doing a Reg S, for example. When they're thinking about that and they're thinking about doing that Reg S offering as a digital asset, what are some things that they have to keep in mind? You know, they might just think, oh, okay, yeah, I filed my Reg S, I can now do whatever I want, right? But obviously they have some other things to keep in mind, you know, social media lockups, NDAs. Can you walk us through what people have to think about for that type of scenario?
Sure, and I think this is actually something I think is very interesting and is an evolving point of law, and I don't want to say enforcement, but just regulatory views. And the way that I've come to these sorts of views generally is through interactions with FinHub, right? Because some of the things that I'm about to say they're not necessarily written in the law. And in the ordinary course, if you were doing a Reg S offering, you might not have needed necessarily to consider all of these things in all of these circumstances. But there are some nuances with respect to digital assets, particularly because of the liquidity and the flow, and the idea that I can't speak on behalf of a regulator, right? So I'm not, but this is just my view after a lot of interactions, is that at some level the US views, or the regulators view the US as having, as one of my colleagues said, a giant vacuum to come suck up tokens, no matter where you issue them into, no matter where you offer and sell them into. So where that ends up, just starting from the beginning, you may ordinarily have a situation where you have a non-US issuer, right? And you say, okay, this transaction, it's category 1, right? And I don't have any duty to police flowback, I being the issuer, right? I have no duty at all. There was a policy decision made that this is category 1, and that means you don't have to worry about flowback. However, when you go and speak with the regulator, you will find generally this idea that, but of course, in this situation, there's a belief that tokens will flow into the US, that there's an interest in tokens flowing into the US from people in the US, and the people who are issuing them outside of the US want and know that they will go into the US. So it's led to some interesting conversations, as a result of which various projects have decided to impose technical and contractual lockups, where ordinarily they might not be required to at all. And I've seen those go as long as, well, I won't say what the end date would be, but sometimes they might be 4 months, sometimes they might be 40 days, sometimes they might be longer or on a linear release. But this is something where, and I'll just touch upon this for a second, and then I'll go back to some of the other things, but where I think it's really, in my view, in many cases, a good idea to actually go with your lawyer and speak to FinHub, because you can say, this is what we're thinking. And, if you were just looking at the law and what you would do, say in an equity situation, you would never know this, right? And you would never have the back and forth to try and craft a solution. And I think that's one of the really important things in our space, is crafting a solution with regulators before you do something in many cases, particularly if it involves the US, or could. Some other things just to be wary of, we live in a social media world. And so if you're putting things on Twitter about this purported Reg S offering, it's going into the US. And so the question of, are you targeting the US? Is there substantial market interest, US market interest? These things take on a different view. So in working with the regulators, in some instances where there may have been, a Reg S transaction sale, running the wireframes by FinHub and saying, this is what's proposed. We're going to geo-block the US. We are not going to talk on social media about it. We are not going to comment about this in the press. If it gets into the press, fine, but we, and by we, I mean the issuer, are not actually going to say it. And in some instances, I've seen where there's like a claims process and or an NDA, some sort of self-certification that you're purchasing for consumptive use and not with a view to investment, all kinds of other things that you likely would never see in a Reg S equity offering. So I say this, there's more stuff that I could go into, but I will say my little plug for going and talking to FinHub, if you are a project that wants to be compliant and you're trying to stay outside of the US, even if you think, what, my customer base for these tokens, it's outside of the US, and I'm outside of the US, still in this world, it's a very different landscape. And I think it's better to be, in many cases, perhaps not all, but to be safe then, sorry. In any event, it's something to think about.
And John and Nina,
actually,
yeah, please.
Yeah, I actually think, MiCA is a bit walking into the same direction. They have explicit and very strict rules around public communication about token offerings. This does not, directly refer to securities, as securities are regulated in the MiFID and not in the MiCA, but I think that will be adopted sooner or later. So it's not only like the white paper requirement, kind of a mini prospectus, but the regulation also catches all sorts of other public communication about these offerings. So I think we will see this further and further, because this idea of entering a geographically defined market doesn't really work in times with internet and social media anymore.
Yeah, and I think that is the challenge with this space as well. As Josh says, this is a global market, and whenever any of us speaks to clients, they say we want to do this globally, and you say, well, that's quite difficult when you've got kind of national laws that treat these issuances in very different ways sometimes. And again, from a UK perspective, it is interesting. There's a consultation already out from UK government, which was last year, suggesting that crypto assets should all fall, even though the crypto asset itself is unregulated. So, as Josh said, some crypto assets are outside the regulatory perimeter. The promotion of them would be regulated if it was a promotion to UK consumers, which is quite interesting and radical in its own way, right? So you can have an unregulated token, but the promotion of it would be regulated.
And I mean, a similar thing in the US, where you could have a token theoretically that one may say, this looks nothing like a security in terms of what it does, right? But if you're selling it and you're promoting it in a particular way, saying it's going to go up in value, or you're going to get it listed on a digital asset exchange or something like that, then you could have created a security where one might have argued that one didn't exist. So yeah, I think it's very interesting how you can have a security from the transaction, but then you also have to look at the marketing, and what you say matters.
Yeah, it does. And I mean, it's interesting, isn't it, that, and this is one of the deficiencies around the definitions in MiCA, but it's also one of the problems in the US as well, is, you could have something that if it was not on some sort of blockchain or DLT or whatever issuance, e.g. loyalty points or whatever, that's clearly not regulated. And then you put it on this, and it is regulated. I mean, that's completely bonkers. And that's definitely the effect of MiCA, in terms of the definitions, the way they are.
There is an argument to say that MiCA requires an issuer, and in case of like decentralized systems, that there is no issuer, and hence MiCA does not apply. But I didn't get this really confirmed by now. I think it's an interesting view and a view to take, and I'm not getting tired of holding up the flag and saying, guys, we need to talk about the important question: when is something so decentralized that you accept that you cannot regulate it anymore, right? Like, this is the elephant in the room, so to speak, which officials naturally don't really like to talk about. But I think this is an important question, and we might even need to put more research into that, and to offer definitions or to offer explanations which are understandable. Maybe we as community, we also need to work hand in hand and offer solutions for that.
The problem is there are people definitely within the European Commission, as I understand it, that don't believe in DeFi. They don't believe it's a thing. They don't believe it. They certainly don't believe it's a serious thing, and therefore that's why they don't think it's worth covering with MiCA, as I understand it.
Well, I think most of them don't believe that there is such thing as DeFi, right? Yeah. They believe that in most instances, and maybe they are not that far away from the truth, there is still a centralized element here, and there is still somebody making money out of that. So I agree that you always need to take a deep look into the tech to actually determine whether something is worth being called DeFi.
Yep. Yeah, absolutely, you do.
From a US perspective, From a US perspective, I mean, the idea of DeFi, obviously, we on this panel and I think broadly in the space have a sense of what DeFi is, but I think from a regulatory perspective in the US, you have to look through the words to actually what's happening. And so I think that's one of the things, just like when people were saying, oh, I have a utility token a few years ago, you know, when that was like the theater, utility token theater, you know, in other countries, in other jurisdictions, there is such a thing as a utility token. In the US, no, you're still running the same tests, you're still doing the same analysis. And so I think for DeFi, when people say, no, it's different, it's DeFi, my understanding is that from the regulator's perspective, no, it's like, what is this individual thing doing? How is it working? And the SEC, for example, has not been shy in finding an issuer where one might argue that there wasn't one. For example, with the DAO report, it's line in the sand in 2017, July 2017, I believe, where they found that Slockit, the promoters of the DAO, which was a decentralized autonomous organization, right, that was actually the issuer, right? They'll find an issuer. Or when you look at the DEX, Ether Delta, right, and where they did an enforcement action against Zachary Coburn. Now, he wrote the code. He was doing other things as well, right, in terms of having control of certain things. So query how decentralized it was, if you look at the order books and things like that. But I just think relying upon this idea that there's no person responsible, I think the regulators, if they think that something is going awry or is not protecting in the right way, they will find, at least within the US, I can't speak for other jurisdictions, they will find an issuer.
Yeah, and I think the way that, I think the European Commission, or certainly individuals in there, and there's an individual from the European Commission that talked at a conference that we co-hosted that referred to as sneak oil, which I thought was extremely unhelpful. I think that within EU, UK, given they're two different things now, that I think regulators would try hard to find an issuer. And Nina's point is absolutely right. When you dig deeply into these things, there maybe is an issuer, and there is, what I always say to clients is, are you making money from this? And can you change the code or take part in the governance of this protocol? Because it's a bit like if you have a client that truly launches an open source protocol that they can have no influence or control of, and they're not going to make money from, that is DeFi, right? But why would you do that, right? And some people do that, but I think it's in my experience, not actually that commonplace. I don't know if your experience is any different, Nina.
What we actually see a lot is that some open source, truly decentralized, organized infrastructure is put in place to then build the user-friendly bridges into those, and then to earn money with the bridge that you build. From a German perspective, that doesn't really help, because the bridge would then be a financial service provider. If that what is used on the decentralized network qualifies as a financial instrument, and her definition since early 2020 in Germany, basically everything that is tradable is a financial instrument. So we captured them all. There are different ways and mechanisms, and another challenge that we often struggle with is the question whether you involuntarily formed what we call a civil law partnership, or what you maybe would call an unincorporated entity or corporation, just de facto by working together, right? And if you then add a governance structure which permits a joint voting on proposals, then you might get very, very close to forming such a partnership or corporation, however you will call it. And then again, if that is the result, then obviously the token attached to that is a security, again, even from a MiFID perspective. So it's really tricky when you look at these very much highly structured new infrastructure that is being built out there, it's really difficult to determine what exactly these things are. And so I think, you know, if we as a community could come up with proper proposals for the politics, you know, what is, you know, when is such a network really decentralized in an open, inclusive, and transparent manner, so that we support that it's being built because we acknowledge that this is a common good that serves, you know, our society, then, you know, in that case, regulation should look a bit different. And I lack completely the discussion about, you know, this topic. Because everybody is so focused on, you know, first it were the ICOs, the bad guys, and now then Libra came and everybody is panicking, but nobody is really looking at the, you know, at how this technology could serve us right, and try to push that instead of regulate it down.
Exactly. And, you know, and that's why I personally believe that actually applying existing financial services regulatory norms is not the way forward. Let's not start from there. Let's not start from the wrong place. Let's actually, I don't know, as a, you know, as having gone through the dot-com boom and, you know, the internet when it first started being regulated, and people did say, you know, way back in the day, that this internet thing, John, it can't be regulated. You know, it's impossible to regulate. Now, you know, it's even today poses its challenges. You look at Facebook in Australia news, right? Over the last 48 hours or 72 hours. But we figured out. But I think we've got to start from the right place. I completely agree with you, Nina. This is about, you know, democratization of finance, and, you know, and particularly in private markets, coming back to what Polymath do, right? Allowing people to invest in private markets in a more efficient digital way. I mean, it's a fantastic opportunity, but we need to start from the right place. And that's not, you know, and personally, I would, you know, I would crack down on bad actors, because that's also, but I think we need to enable innovation as well. You know, and
yes,
not,
and I think, you know, the way how to reach that is that we actually propose, you know, what should be exempted from financial regulation. And I think what should be exempted is a digital infrastructure which builds a common good based upon our principles, you know, fair, inclusive, transparent. And if that is, you know, not managed by anyone singly or a defined group anymore, then I think we just, you know, need to be grateful that it's there and that it's ready to use. And then we can certainly discuss about, you know, the entry points, to regulate the entry points into such an infrastructure, but we should embrace and welcome that we get such infrastructure. Really, always under the assumption and subject to these things being truly decentralized and not serving a specific, you know, single one's purpose.
And so on that, so John, you know, if we need to start from a more, you know, common sense place. So let's say, you know, you're king of the world for a day, but anything you enact will exist and persist into the future. You know, what regulations do you pass, or what do you think needs to happen specifically for security tokens or capital markets more broadly?
Sorry, who was that a question to, Josh?
To you, John.
All right, sorry.
We can start with you, and then everyone else can be king or queen for a day.
Yeah, but I think what's interesting is, you know, the policymakers and regulators around the world have struggled with crypto, but when crypto assets and digital assets, but when it's mattered, they've made it work, right? Look at AML and, you know, CTF, and pretty broadly through FATF, we've got the same rules around the world. You know, they're differently implemented, and there's different registration requirements, etc., even within the EU. But you know, there's, broadly speaking, we have. So I would like us to have, you know, as you say, being king of the world, I would like us to have broadly equivalent standards. And I completely agree with Nina that this is about we should start with public good. We should start with, but I do think we need to, it's about a starting point, and I think we shouldn't try and shoehorn this into existing regulation because it's never going to work. I do think we should have the same. I'm a great believer in the same standards, right? I don't think we should be saying, right, crypto assets, digital assets, you get a free pass from regulation. But nor do I say we should regulate them out of existence, which I think is a concern. So it's about how do you really encourage innovation, and so technical innovation and financial innovation. And it is a hard thing to do, to regulate to encourage innovation, and you just have to look at things that we've done, PSD2 in Europe, etc. And they quash innovation as well. But I think let's start from the right place. Let's try and do it in a tech neutral way. Again, a very hard thing to do, but if you do it on a principles based, then I think we've got the opportunity of making that work. So that's, sorry, Graham, I could go on forever on this, but that,
No, that's great.
at a high level, I think
Yeah.
we should have broadly equivalent standards, but that doesn't mean that you shoehorn into existing regulation. I think those are two different questions.
Right. Yeah, and then so Josh, where do you think things move forward? So I mean, we've seen lots of enforcement actions. We saw Kick, Telegram. We've seen some new things actually today with Tether happening. But in the security token world, specifically from your US primary perspective, where do things happen with security tokens? Do all security tokens move on to blockchains? Is the SEC happy with that? Are there going to be some things that the SEC does where there's a pushback because maybe we're disrupting CSDs too much and altering business models of the big banks too much? Where are you seeing the future happen, specifically from regulators being comfortable with the technology and actually encouraging the technology?
Thanks. So what I would say, I would say the regulator that I interact with the most closely is the SEC and FinHub. Certainly I work with other regulators as well, but I speak with FinHub on a very frequent basis. From my perspective, there is a great deal of comfort and familiarity with the technology in ways that I think some folks don't understand or expect. Like, the FinHub folks know what sharding is. Like, there's all kinds of things that one may say, no, the regulators wouldn't understand that. Yes, they do. And there are specialists. I can think of at least one in FinHub, like, for example, David Crosby, who normally is a professor of engineering at Penn. I don't know if seconded is the right word, but he's there, right? So as people are presenting, or as they're evaluating different projects or different tokens that are in the market, he's right there with them. And so I think there is a level of sophistication that shouldn't be underestimated. If you do go talk to them, you will see that, right? Like, if you bring them a slide deck and talk through it, they will have very relevant questions. And I think this is across regulators. It was mentioned to me that this past weekend that the various regulatory bodies, including, say, FinCEN and the SEC and others in the US, had some sort of joint working session discussing DeFi and things like that. So I think the regulators in the US are very attuned to this. I think there is a support for the technology. I think in particular, the ability to track and trace, different digital assets, I think that can be very helpful from, sanctions perspectives, also, KYC, AML, et cetera. Also, you can program a lot of compliance into the token itself through lockups and other sorts of things. So I think that the regulators do see a lot of promise in the technology. In terms of whether, the SEC and others might think that something is encroaching upon territory of the big banks, I can't speak to that, but I will say that
I was trying to see if I can get you to, but
I don't in my conversations with them, that hasn't specifically ever come up. But what I have seen, in my view, this is not a regulatory view clearly of a regulator, but is a movement in the US away from the term decentralization in terms of looking at when something may no longer be a security. I think it's been repeated to me multiple times that that was used in a speech one time, and it's kind of taken on a life of its own. I think that there are a number of projects out there that are trying to explore how one goes from issuing a security token that is legally compliant and then seeing when, if ever, it can somehow change and no longer be a security. But I think that's a difficult thing, obviously, to predict. But also, another thing that has been brought to my attention, although certainly we all know this, or at least those of us following the US, is that when you use Ethereum as an example of something that may have been issued potentially, who knows, as a security and then no longer is, sometimes what you'll hear is, but they never got a no action letter, right? So trying to say, well, this project looks like this, that isn't necessarily good enough to get a no action letter. So I think there's a lot that's still in flux and in play, but I think what we've seen in the US is that digital assets issued as securities, some of them have been highly, highly successful, right? And they may not be trading in the US because they're, because certain platforms won't list them because they're likely to be securities, but that doesn't mean that they are not, broadly used. And I think that these are things I'm excited about. And that's what I think a lot of focus is on. Now, may I just say one other thing? I think this might be more of a real world coming together of perception and then regulatory views. But there also are a number of projects that one might say, because you can go talk to FinHub and they can give you certain times no red flags guidance, right? It's not formal guidance, but they hear what you're doing and sounds okay. There are some projects that are like, listen, I need a no action letter because my customers and my suppliers and my joint venture partners, they're not going to trust that this is okay. And so even if you have something that looks very much like an existing no action letter that was issued, and of course you're not allowed to rely on a no action letter for someone else, but just for informational purposes, you may say, oh, you're covered by, or maybe you're comfortable that this covers you, but they may say, no, I need more certainty because there is this level of scrutiny of our industry. And so I think where we're going, at least in the security token space and all that entails, is I think we're going to see, I don't want to use the word clarity because that's overused, but I think we're going to see paths forward. I think the regulators are trying to find paths forward for compliant projects and trying to find ways to get rid of certain obstacles.
Right. And then, so we're at 12:54, so a couple more minutes. So maybe a few rapid fire answers from some of our panelists. So Nina, where do securities lawyers get benefits from security tokens? Is it perhaps in being able to better track where the securities are held, because you can have, for example, whitelisting mechanism where only certain people are able to hold the security rather than having pieces of paper that are flying around in filing cabinets? Is it through standardizing smart contracts? Is it the auditable trail of what's actually happening? Is it you get to have more fun learning new things that you never thought you'd learn? What are the benefits that security tokens bring for someone in your profession?
Well, I think they certainly come with the promise of quicker settlement than within the traditional system, and that helps with certain transactions already quite a bit, I think. And then, otherwise there's not such a huge difference between traditional securities and its digital twin, so to speak. So I think for us lawyers, presumably it doesn't change that much, but it potentially could give wider access to these kinds of instruments, but that's depending upon the regulation that we're seeing. And I would like quickly, jump on the topic that you raised, John. You said you would love to see like a global standard developing. I can report that there is a UNIDROIT, which is like the legal department of the United Nations. There is a working group on digital assets working on a proposal to the global legislators how to actually deal with tokens and how to, define control, custody, and all those, really central terms that we need. That's a good thing. I'm part of that. It's a really highly interesting discussion going on there. On the other hand, I'm also afraid of a global standard because law is decentralized by nature, right? It's split out across the globe. I agree with you that we maybe have too many jurisdictions with nearly 200 countries being part of the United Nations, and then tons of bilateral or multilateral agreements even overriding it. But I personally would not like to see the whole earth being regulated by only one regulation, which would not leave us a choice if we don't like or don't agree with the principles set forth therein. So I always say, be a bit cautious, not asking for too much. And other than that, Graham, if I may, another topic we didn't touch upon, but which is also very important, is that we need to balance AML rules, the FATF rules, and the privacy rules, right? Both regulations, anti-money laundering and privacy, are developed in their silos. And we must bring the experts together and talk together because that doesn't work, right? We are seeing so many conflicts between AML efforts on the one side and privacy efforts on the other side. And we need to bring those people on one table and to find a proper solution which is sufficient for prevention of money laundering and terrorist financing at the same time as it protects the privacy of the people out there.
I couldn't agree more, Nina, and I think that's the real battleground, isn't it? In and it's going to be, FATF are apparently going to come out with new proposals on unhosted wallets this quarter, next quarter, and I think it's very, the argument goes, well, why should there be, harsher regulation around this than cash?
Yeah, and Josh, I remember us discussing in the Wharton group already years ago the question when the regulator will actually jump on the idea to regulate technology as such, or coding, make coding a regulated profession.
And there's a tension there, right, between that and free speech.
Yeah,
right?
yeah, and privacy generally, right? I mean, yeah. I mean, there's a lot of chat just in the last couple of days about the CBDC in Asia, but you do wonder how much that's going to be tracked and traced, right?
Yeah, that's Big Brother.
Well,
yeah.
Sorry,
I
Graham.
think no worries. This has been an amazing chat. I know lawyers can talk all day, and you guys did not disappoint. So we're approaching the 1 hour mark. So maybe one last sentence from each of you. What does the future of security tokens look like? One sentence. Josh, we'll start with you. I'll give you two sentences if you need.
Security tokens will. This is hard to do in one sentence. I think security tokens are continuing to be relevant. I think they'll become more relevant. I think we're going to see more and more ways for them to be able to be used without hurdles, in my view,
Awesome.
not investment advice.
Love it. Of course. John, one sentence, maybe two.
I think we'll see, particularly in the private market space, developments of security tokens and appropriate proportionate regulation.
Awesome.
Because I'm an optimist.
Good. Love to hear it. Nina, last word.
Okay. I am pretty sure that security tokens will reach mass adoption. The question is whether they will reach the people peer-to-peer and how much freedom we will actually get to handle them without licensed intermediaries.
Awesome. A perfect last word, I must say. So thank you, panelists. Thank you, Nina. Thank you, John. Thank you, Josh, for giving us your time. I know the attendees had a great time learning from you. And to all the attendees, we will publish a recording of this. So don't worry, you'll be able to listen back to your favorite parts and keep learning from all these great people. John, I know you're going to watch this back. Don't lie. I know you are. So again, thank you guys so much. And it seems like we'll have to do this again sometime. So hopefully we can at some point in the future and discuss predictions and regulations as they've evolved from this chat. So thank you, everybody, and have a